Hello, dear students. I hope you are all doing well. The wait is over. The practice batch is here. It's time to gear up and focus on honing your skills. In this batch, you will get dictations from SSC's previous years, including 2024, 23, 22, and beyond. Each video will feature dictation from one shift. Your responsibility is to practice each of these dictations diligently to achieve excellence. Let us now begin the session. Listen carefully and write with full concentration. All the best. Ready for the shift third matter. Get ready. Start. Learned counsel for the respondent contended that the observation was clearly in the nature of an obiter dicta and did not lay down the correct law. That was the case which respondent number 1 had entered into a contract with respondent number 2 for taking advances of the security of the factory premises, plant and machinery. A mortgage was executed by him in favor of the respondent bank. The bank insured the mortgage properties from time to time with the appellant company under different insurance policies. A fire broke out in the factory premises, and the insurance company was duly informed. The survivor estimated the loss at rupees 4,600 without prejudice to the terms and conditions of the policy. After some correspondence, the appellate insurance company repudiated the claim under the terms of the policy. Thereupon, respondent number 1 wrote to the insurance company that since it had repudiated the claim, a difference had arisen between the parties and appointed a sole arbitrator to decide the dispute. At the same time, it mentioned that if the insurance company desired to nominate an arbitrator, it may do so. The insurance company, however, took the stand that since it had repudiated the claim, the arbitration clause in the policy was rendered inoperative and no arbitration proceedings could legally be initiated. This led to the respondent number 1 filing an application under section 20 of the Arbitration Act. The application was contended, and since the trial court held that on the repudiation of the claim under clause 13, the dispute fell within the scope of the arbitration clause 18 but was barred by limitation in view of clause 19. The High Court therefore reversed the trial court order and remanded the case for appointment of arbitrators. The insurance company carried the matter to this court while dealing with the submissions of the bar. This court, in paragraph 8 of the judgment, observed that only one point need to be decided, namely, whether, in view of the repudiation of the liability under clause 13, a dispute was raised which could be referred to arbitration. It also said that incidentally reference will be made to the other question as to whether the proceedings were barred by clause 19 of the policy. This court answered the first point in the negative, and hence no decision was necessary on the second point, but the court answered it only incidentally. This is also clear from the observation extracted earlier from the case law referred to above. The legal position that emerges is that an agreement which seeks to curtail the period of limitation and prescribes a shorter period than that prescribed by law would be void as offending section 28 of the Contract Act. That is because such an agreement would seek to restrict the party from enforcing his right in court after the period prescribed under the agreement expires, even though the period prescribed by law for the enforcement of his right has yet not expired. So far as the filing of complaint directly before the commission because of higher valuation, the procedures laid down in rule 14 of the rules have to be followed, and in that case the name of the opposite party has to be given so far as they can be ascertained. In the present case, the appellate filed a original petition impleading the institute where her husband was admitted as a party, but she did not impede the treating doctors and nurses who were attending on her husband. Though the commission directed that necessary parties may be impleaded, and it appears that no effort was made to implead the treating surgeon or the nursing staff as a party. Therefore, the question is whether non impleading the treating surgeon or a nursing staff can be said to be necessary party, and if they are not impleaded, then in the case the original petition can result into dismissal on account of non-joinder or necessary party. So far as the law with regard to the non-joinder of necessary party under Code of Civil Procedure, Order 1 Rule 9 and Order 1 Rule 10 of the CPC, there also even no suit shall fail because of misjoinder or non-joinder of parties. It can proceed against the persons who are parties before the court. Even the court has the power under Order 1 Rule 10 for to give direction to implead a person who is a necessary party. Therefore, even if after the direction given by the commission, the concerned doctor and the nursing staff who were looked after the deceased A.K. Garg have not made impleaded as opposite parties, it cannot result in dismissal of the original petition as a whole. The consumer forum is primarily meant to prove better protection in the interest of the consumers and not to short circuit the matter or to defeat the claim on technical grounds. Reverting back to the facts or of the present case, whether non-joinder of the treating doctor, nursing staff can result into dismissal of the claim petition. As a matter of fact, when a patent is admitted to the highly commercial hospital like the present institute, a thorough checkup of the patient is done by the hospital's authorities. It is the institute which selects after the examination of the patient that he suffers from what malady and who is the best doctor who can attend, except when the patient or the family members desires to be treated by a particular doctor or the surgeon, as the case may be. Normally, the private hospitals have a panel of doctors in various specialties, and it is they who chooses who is to be called. It is very difficult for the patient to give any detail that which doctor treated that patient and whether the doctor was negligent or the nursing staff was negligent. It is very difficult for such patient or his relatives to implicate them as parties in the claim petition. Stop. So, how was the dictation? I hope you managed it. Write it well. Don't forget to share your scores in the comments. I do love to know how you did. By the way, the dictation was clear, right? Let me know if you faced any issues. Keep practicing regularly, and I am sure you will do great in your exams. Good luck and keep up the hard work. Thank you so much.